All right, so estates and inheritance. Not exactly a topic that screams party time, right?
Right, but it is important.
Oh, absolutely. And we've got this study guide to help us unpack it all,
Yeah, it's great. It covers both common law and customary law.
which is perfect for South Africa because, well, we've got this unique blend of both. So let's dive in. Study Unit 1, Introduction to the Law of Succession. Where do we even begin?
Well, the study guide starts by saying that for succession to happen, someone has to,
Passed away.
yeah, death is the trigger, both in common law and customary law.
Okay, that makes sense. It's about what happens to your stuff after you're gone. But what if someone just disappears?
Ah, that's where things get interesting. The study guide talks about the presumption of death.
Presumption of death.
Yeah, so if there's enough evidence that someone's gone, even without a body, the courts can declare them legally dead.
Whoa, really? So even if there's a tiny chance they're still out there, their stuff could be divided up.
Exactly. But the study guide mentions that the heirs might have to provide some kind of security, like a financial guarantee, just in case the missing person pops up again.
It's like the law is saying, hey, life's unpredictable. Anything could happen.
Right. Okay, so we've got death, or at least the presumption of death, to kick things off. What else is in this intro unit?
Well, let's see. Oh, he talks about the nasciture as fiction.
Oh, yeah, that's a fascinating one. Basically, it means a child who survives birth is considered to have rights from the moment of conception, but only if conception happened before the parent died.
Hold on. So even an unborn child can inherit.
Exactly. It's all about protecting their potential rights. And the study guide even goes into how this applies in some pretty tough situations, like the ex parte Graham case, where a husband murdered his pregnant wife knowing she was carrying his heir.
Oh, wow.
Yeah, heavy stuff. He was disqualified from inheriting anything, and the inheritance was saved for the child.
It's amazing how the law tries to navigate these ethically complex situations.
It really is. And then the study guide throws another curveball. Comorientas.
Comorientis.
It's when multiple people die in the same disaster, and you can't tell who died first.
Oh, I can see how that would create problems with inheritance. If you can't figure out who died first, how do you know who gets what?
Exactly. The study guide points out that in South Africa, there's no presumption about the order of death in those cases. The point has to look at all the evidence and try to piece it together. There was this case, Grayling v. Grayling, where a couple died in a car crash, and figuring out who died first decided everything about the inheritance.
It's like a legal detective story. Death, presumption of death, unborn heirs, figuring out who goes first in a disaster. This intro unit is packing a punch.
It is, but it's setting the stage for everything else. And next up, the study guide moves on to Study Unit 2, Intestate Succession.
Okay, intestate succession, that's what happens when someone dies without a will, right?
You got it. No will, no problem, at least as far as the law is concerned. The Intestate Succession Act steps in and has its own set of rules about who inherits what.
So let's say someone dies. They have a spouse and children. How does the inheritance work?
Okay, so the surviving spouse inherits either a child share or a minimum amount that's set by law, whichever is bigger. Then the rest gets split equally between the kids.
And a child share changes depending on how many children there are, right? More kids, smaller share.
Yep, exactly. And the study guide walks through all kinds of different scenarios. What if there's no spouse? What if the parents are still alive? What if someone's disqualified from inheriting because they were, say, involved in the deceased's death?
Wait, disqualified, you can be cut off from an inheritance, even if you're family?
Oh, absolutely. It's called the bloodage hand principle. Bloody hand. You can't profit from your own wrongdoing.
Wow, intense. So even without a will, things can get really complex.
They can, and the study guide really emphasizes knowing these rules, especially if you don't have a will. It's about knowing your rights and what to expect.
Right, because even if there's a law, it doesn't mean there won't be family drama. Okay, so intestate succession is all about the law stepping in when there's no will. But what about when there is a will? That's where Study Unit 3, wills, comes in, right?
You got it. The study guide lays it out. A will is basically your written instructions for how you want your stuff handled after you're gone. You get freedom of testation. You decide who gets what.
That sounds pretty powerful. So could I, leave my entire fortune to my pet goldfish if I wanted to?
Well, maybe not your goldfish, but you do have a lot of control. But the study guide does point out that this freedom of testation, it's not absolute. There are limitations.
Okay, so you can't just write anything you want in a will and expect it to be followed to the letter. What kind of limitations are we talking about?
Well, there are statutory limitations, like the Immovable Property Act. That puts limits on how long you can restrict land ownership. You can't just lock up a piece of land in your family forever. And then there are common law limitations, like a will can't go against good morals or public policy.
Interesting. So what if someone does put something in their will that's against public policy?
Well, the study guide brings up this really interesting case, Minister of Education v. Seifert's Trust, Ltd. There was this trust fund from back in the 1920s, and it said the money could only be used for bursaries for white, non-Jewish male students.
Oh, yikes. Yeah, that definitely wouldn't fly today.
Exactly. The case went to court much later, and those discriminatory provisions were deleted because they went against public policy. It shows how societal values and the Constitution can impact what's considered acceptable in a will.
So a will from 100 years ago might not hold up in court today. Things change, right?
Exactly. And the study guide really stresses that the law of succession is always evolving.
Okay, so wills give you a lot of control, but within certain boundaries. But then the study guide also talks about testamentary capacity, which makes it sound like not everyone can just make a will.
You're right. In South Africa, you have to be 16 or older, but you also have to have the mental capacity.
So you have to be the sound mind, right? What does that actually mean when it comes to making a will?
The study guide lays it out pretty clearly. You have to understand what you're doing, be aware of your property and who would normally inherit from you. It's about making sure the will reflects your true intentions.
Makes sense. Are there any cases where this was, kind of challenged?
Oh, definitely. The study guide mentions Spies v. Smith, where the person making the will was having delusions, and the court decided they didn't have the capacity to make a valid will.
Wow, so mental state really matters, especially with legal documents. But it's not just about WHO making the will. There are all these formalities too, right? Like how it has to be signed and witnessed.
Exactly. The study guide goes into a lot of detail about the Wills Act, which basically lays out all the hoops you have to jump through to make sure your will is valid.
So what if you try to DIY a will and you mess up the formalities?
That's when things can get messy. The whole will could be thrown out, and then you've got family feuds and legal battles. The study guide is pretty clear on this one. Get professional help when you're creating or changing a will.
Yeah, DIY wills sound like a recipe for disaster. Okay, so wills give you control, but they have to follow the rules, and you have to be mentally fit to make one.
Got it. But what about controlling how your property is passed down over multiple generations? I've heard of things like fideicomissa and usufructs.
You're thinking along the right lines. The study guide has a whole section, Study Unit 4, Fideicomissa, Usufructs, and Trusts, all about that. These are tools for more complex estate plans, the kind that can span generations.
Okay, break it down for me. What's a fideicomissum?
Imagine a grandparent wants to leave their farm to their child, but they also want to make sure it eventually goes to the grandchild. They can set up a fideicomissum where the child inherits first, but then has to pass it on to the grandchild later. It's like a built-in inheritance chain. So it's a way to control the family legacy, make sure certain assets stay within a specific line. What about usufructs? How do those work?
A usufruct is kind of like having the benefits of ownership without actually owning the thing. Like, say a spouse gets a usufruct over the family home. They can live there for the rest of their life, even though the actual ownership passes on to the children.
Interesting. So it's a way to provide for someone without giving them complete control. And then there are trusts. Trusts seem to be really popular these days.
Trusts are super flexible. You create this separate legal entity, the trust, and you transfer assets to it. A trustee, someone you choose, manages those assets according to your instructions for the benefit of your beneficiaries.
So it's like having your own personalized asset management system, even after you're gone. Are there any rules about how you can set up a trust?
There are definitely rules, but trusts offer a lot of customization. You decide who benefits, how they benefit, when they benefit, what happens to the assets later on. The study guide even mentions this case, Braun v. Blon and Botha, where the trustee got to choose the beneficiaries from a specific group.
Wow, so it doesn't always have to be a straightforward inheritance. Trusts sound like a pretty powerful tool.
They are, and they can be really useful for protecting assets, managing complicated family situations, achieving charitable goals.
Okay, so we've covered a lot here, but there's one more thing in this study unit that I want to touch on. Collation.
Ah, yes, collation. This is all about fairness. It kicks in when someone gets a substantial gift from a parent while that parent is still alive. That gift needs to be factored in when the estate is divided later, so no one gets an unfair advantage.
Can you give me an example? How does that work?
Sure. Imagine a parent gives one child a big chunk of money as a gift. When that parent dies, the value of that gift gets added back into the total estate value before it's divided between the heirs. So the child who got the early gift doesn't end up with a much bigger inheritance than everyone else.
Ah, I see. It's about making sure everything is divided fairly in the end.
Exactly. The study guide stresses that collation is really important for equitable distribution.
Wow, this deep dive is already making me rethink my whole approach to estate planning.
It's definitely a lot to take in, but having this transitional knowledge from the study guide is a great start.
Absolutely. Death, intestate succession, wills, and even some advanced planning tools. What else does the study guide have for us?
So we've talked about trusts, collation. Pretty interesting stuff, right?
Yeah, definitely makes you think.
Right. And the study guide keeps going deeper. Study Unit 5, testamentary capacity and the formalities of a will.
Ah, yes, testamentary capacity. We touched on that earlier, but this unit seems to really zoom in on it. Why is that so important?
It's about making absolutely sure that the will really reflects what the person making it wanted, because not everyone is actually legally capable of making a valid will.
Right, right. We know you have to be 16 or older in South Africa, but what about this whole sound mind thing? The study guide uses the term mental capacity. What does that even mean, legally speaking?
It's pretty clear-cut in the study guide. The person making the will, the testator, has to understand what they're doing. They have to grasp the implications of their choices, be aware of what property they own, and who would normally inherit from them.
So it's not just about being, like, conscious. It's about being fully aware and in control of your decisions, making sure the will isn't some spur-of-the-moment thing or made under pressure.
Exactly. The study guide even uses the term conscious volition. Like, the will has to be a product of their own free will, and anyone challenging the will has to prove that the testator didn't have that capacity.
So if someone thinks there was something fishy going on, they need to have strong evidence to back up their claims.
Oh, absolutely. The study guide mentions that courts look at all sorts of things, medical records, what witnesses say, even the actual content of the will, trying to figure out what the testator's state of mind was.
It's like a legal puzzle. Okay, so we've got mental capacity, but then there's this whole thing about formalities too, right? All these rules and regulations, why are they so important?
Think of them as safeguards, like against fraud or disputes. The Wills Act is super specific about the procedures you have to follow to make sure a will is genuine and truly reflects the testator's wishes.
Okay, so what are some of the big requirements?
Well, the will has to be in writing. No verbal agreements, no scribbles on a napkin.
It has to be a proper document, huh? Like something you'd see a lawyer with.
Yeah, exactly. And the testator has to sign it with at least 2 competent witnesses present.
Witnesses, that's interesting. Why are the witnesses so important?
They're there to confirm everything. Their signatures prove that they saw the testator sign the will and that the testator seemed to be of sound mind and acting freely.
Ah, so it's all about creating this clear record of what happened.
Right. And the study guide points out that witnesses can't be beneficiaries of the will. That would be a huge conflict of interest. And they also need to be mentally capable of understanding what they're doing.
Yeah, you wouldn't want someone who's easily swayed or confused to be a witness.
Exactly. All these formalities might seem a bit tedious, but they're there for a reason. To protect the testator and prevent any funny business.
Okay, so in writing, signed by the testator, witnessed by 2 unbiased and competent people. What if someone messes up these formalities? Is the whole automatically invalid?
It's not always a slam dunk. The study guide talks about something called condonation, where a court might accept a will even if it doesn't tick all the boxes perfectly.
Condonation. So there's some wiggle room. When would a court actually do that?
It's not something they do matter. The study guide makes it clear that condonation is really a last resort. They only grant it when there's clear evidence that the will reflects what the testator actually wanted and that any mistakes were genuine or couldn't be avoided.
So it's kind of like a safety net for those who made honest errors or faced some really difficult circumstances.
Yeah, I guess you could say that, but the court has to weigh the risks, balance the potential for fraud against upholding the testator's right to decide what happens to their property. It's a tough call.
It definitely sounds like getting expert legal advice when you're making or changing a will is the way to go, based on this study guide.
Oh, 100%. Even small errors can have huge consequences. That's something the study guide really stresses.
Okay, so we've got creating a will, we've got amending a will, and all the legal hurdles involved. Anything else this study unit on wills covers?
Yeah, it actually goes into amendments of wills, which are basically changes to a will that's already been made.
So you don't have to scrap the whole thing and start over if you want to make some changes?
Nope, but here's the thing. Amendments have to follow those same strict formalities. You can't just add a note in the margin and expect it to count.
The same rules apply. In writing, signed, witnessed, everything.
Everything. Every change, no matter how small, has to be treated like a mini will and go through all the same legal hoops.
So consistency is key. What if someone makes an amendment that doesn't follow the rules? Is the whole will thrown out?
It depends. The study guide says that the court might uphold the original will and just ignore the botched amendment. Or they might try to figure out what the testator really wanted, even if the amendment wasn't done properly.
So even with all these strict rules, there's some room for interpretation.
Yeah, but that doesn't mean you should take any chances. Get professional help with amendments. That's the study guide's advice. Saves you potential headaches down the line.
Definitely good advice. Okay, so we've covered making a will, changing a will, and all the hoops you have to jump through. What else is in store for us in this study guide?
Well, it moves into a pretty sensitive topic. Study Unit 6, Disqualification from Inheriting.
Disqualification. Oh, that sounds serious. Who gets disqualified and why?
The study guide actually lists several categories. We already talked about someone being responsible for the deceased's death, that whole bloody hand principle.
Right, right. You can't inherit from someone you harmed. It's just wrong. But are there other reasons someone might be disqualified?
Oh, absolutely. The study guide mentions witnesses to a will. They can't be beneficiaries. It's to avoid conflicts of interest, keep the whole witnessing process above board.
Makes sense. It would prevent anyone from accusing the witnesses of, manipulating the situation.
Exactly. And then you've got disqualifications that are based on public policy, like if someone's been convicted of certain crimes, like fraud or forgery, they might be barred from inheriting.
Wow, the law really comes down hard on those who break the rules.
It does, but it's not always automatic. A court has to decide based on the specific circumstances of each case.
So there's always room for legal debate and interpretation.
Right. And speaking of interpretation, we can't forget about customary law. The study guide has Study Unit 7, The Impact of Customary Law, all about this very topic. It really emphasizes how navigating inheritance can be even more complex when customary law is involved.
Yeah, it's like we've got two separate legal systems running in parallel in South Africa. What are some of the big differences we need to keep in mind?
Well, one of the main ones is how spouse is defined under customary law. Unlike common law, where you generally only have one spouse at a time, customary law allows for polygamy.
So a person can have multiple spouses at the same time. How does that affect inheritance?
It can definitely complicate things. The Intestate Succession Act has to be interpreted in light of those customary law principles.
I bet that leads to some interesting calculations and maybe even disagreements between potential heirs.
You got it. And it's not just about spouses either. The whole idea of family and kinship is often broader under customary law, so that can change who's considered an heir and how the inheritance is divided.
It's almost like a whole different set of rules and traditions.
In a way, it is. And to navigate it properly, you really need a deep understanding of both legal systems.
So it's not just about knowing the law, it's about understanding the whole cultural context, too.
Exactly. And the study guide really highlights how important it is to get expert guidance when you're dealing with estates that involve customary law.
Okay, so we've got common law, we've got customary law, we've got wills and testacy. It's a lot to wrap your head around. But the study guide isn't done yet. It has a whole section on Study Unit 8, Freedom of Testation Limitations. Didn't we already cover that?
We talked about it a little bit, but this unit goes into much more detail. Remember how we said that a will gives you the power to decide who gets what, but that power isn't unlimited?
Right. We talked about how you can't put things in your will that are illegal or against public policy. What other limitations are there?
Well, this unit dives deeper into the Immovable Property Act and how it limits long-term control over land ownership.
So you can't just keep a piece of land tied up in your family forever.
No, and the study guide also highlights this concept of maintenance, which can actually override freedom of testation in certain situations.
Maintenance, you mean like spousal or child support?
Yes, exactly. Even if a will explicitly disinherits someone, the law still recognizes the obligation to provide for dependents, like minor children or a surviving spouse.
So even if you write someone out of your will, you can't totally cut them off if they have a legal right to financial support.
That's right. The duty to maintain overrides freedom of testation in those cases. It's like a safety net.
Interesting. So even with a will, there are limits to how much control you have.
Absolutely. The law tries to find a balance between individual wishes and, society's obligations.
Okay, so freedom of testation has its boundaries. What else does this unit cover?
It also delves into some of the hot button issues surrounding maintenance, particularly the rights of unmarried partners, especially in same-sex relationships.
Oh yeah, that's an area where the law's been changing a lot lately.
It has, and the study guide points out that there have been court rulings that both expand and limit maintenance rights in these situations. It's a really complex and constantly evolving area of law that reflects the changing nature of families.
So even something like maintenance, which seems pretty straightforward at first glance, can get really complicated when it comes to estates and inheritance.
Oh, it definitely can, and the study guide makes it clear keeping up with these legal changes is vital for anyone involved in estate planning.
Well, this deep dive has been, wow, a real eye-opener, to say the least. Death, intestacy, wills, advanced planning, the limitations of freedom of testation.
And we're not done yet. There's still more to uncover in this study guide.
Bring it on. What's next on our journey through the world of estates? Okay, so we've gone through wills, intestacy, all those limitations on freedom of testation, even touched on customary law. What else is there to unpack in this study guide?
Well, the final part is Study Unit 9, Administration of Estates. It might not sound as thrilling as some of the other stuff, but it's where things get real, like actually dealing with someone's estate after they've passed away.
Okay, I'm listening. What's so important about the administration of estates?
Basically, it lays out all the practical steps, the legal processes that have to happen after someone dies. And the study guide really highlights the role of the master of the high court. They're kind of like the overseer, you
So
know?
they make sure everything is done correctly, fairly, legally when handling someone's assets after they're gone.
Exactly. They have a lot of authority, appointing executor, examining wills, approving how assets are distributed. They even resolve disputes between heirs. They're the big cheese when it comes to estates.
Sounds like a pretty important job. What are some of the steps involved in administering an estate?
Well, first things first, you have to report the death to the master's office. Then, if there's a will, it gets submitted for examination.
And if there isn't a will?
Then the master appoints an executor to handle things according to the rules of intestate succession, which we talked about earlier.
Right, right. So the executor is like the estate manager, making sure everything is handled according to the law or to the will.
Exactly. They have to identify and gather the deceased's assets, settle debts, and then distribute what's left to the heirs or beneficiaries. Big job.
That sounds like a lot of responsibility, especially if the estate is big or complicated.
It can be. The study guide stresses how careful executors have to be. They're answerable to the master of the high court for every decision they make.
So there's a lot of oversight to make sure everything is done right.
Definitely. It's all about protecting everyone involved, making sure the deceased's wishes are followed, or if there's no will, that the law is applied properly.
Wow. This deep dive has been quite a journey. We've gone from, like, the very idea of succession to the practicalities of handling an estate.
It has been quite a ride through the world of estates and inheritance. And this study guide, it's been fantastic, really gives you a solid understanding of a complicated area of law.
Absolutely. It makes you realize how important planning is and understanding all these legal details.
Couldn't agree more. Whether you're writing your own will or trying to figure out an inheritance, knowing this stuff is crucial.
Well said. So there you have it, folks, our deep dive into estates and inheritance. Hopefully you found it informative, maybe even a little bit fun.
And remember, if you're dealing with any of this in real life, get professional legal advice. It's always a good idea to have an expert in your corner.
Couldn't agree more. Until next time, keep those legal minds sharp, and remember, a little bit of knowledge can go a long way when it comes to protecting your legacy.